Third case on this morning's docket, that is case number 114834 in the matter of ADT.
Your Honors, my name is Deborah Erickson, and I'm from Wyandotte County, and I represent ADT. I would request 2 minutes for rebuttal.
2 minutes is granted.
As a quick summary of this case, ADT was 13 years old and was charged with the crimes of first-degree murder and criminal possession of a weapon. He was charged, obviously, as 13 years old in juvenile court of Wyandotte County, Kansas. He went through a waiver hearing. The court determined that waiver wasn't appropriate. He ultimately entered a plea under the Extended Juvenile Jurisdiction Act and received a juvenile sentence and an adult sentence. He served the juvenile sentence, which has good time credit, and was released and had to serve some post-juvenile release time. And then while on that post-juvenile release time, had a violation of the conditions of his probation, had a hearing in front of the judge as to whether or not he had a violation of the conditions of his probation, and then the extended juvenile jurisdiction adult sentence was then enforced, and he has been given a life sentence with a hard 25 minimum.
How old was he when he
committed the crime?
When not committed the crime, but when he was committed the release time conditions, or the conditions?
Well, he was 13 when the crime was committed. He was released from the facility in June of 2013. So that would have been 4 years later.
4 years, so he makes him about 17, and then when were these?
Approximately a year after that.
Okay, so he was about 18 years old when
I think he was over 18 at that time.
When the conditions of his release were violated.
Yes.
Okay, thank you.
Counselor, while you're stopped here, do you contest whether the period of conditional release is part of the juvenile sentence?
I believe that the period of release is part of his juvenile sentence.
Because the statute basically says if they fail to perform or complete their juvenile sentence, then they're subject to lifting the stay on the
adult extended juvenile justice.
And I understand it's your contention that there were constitutional violations that led to his having to serve the adult sentence, but I'm not sure I see what constitutional provisions were violated.
What I believe is that there's a manifest injustice as to what occurred in his case. I know that those cases...
And where does manifest injustice come from? Lead me to that through whichever constitution you're
well, I believe it's twofold. One, I believe that he wasn't instructed at the time of sentencing what could result in a revocation of that juvenile stay.
And did he move to withdraw his plea? Because he entered a plea.
He entered a plea.
Okay. And you're saying that plea was not knowingly and voluntarily entered because he didn't know the consequences of that plea?
He did not know at the time of the revocation hearing that what the consequences were when the judge advised him at sentencing. In other words, the judge advised him at sentencing. The only thing
sentencing for the violation.
Sentencing in the original sentencing in this case. The only thing
my question was, if you're saying there was a flaw in the original sentencing, then why isn't the remedy to seek a withdrawal of plea because he wasn't fairly informed of the consequences of that plea, rather than you're asking that he be returned to juvenile for additional juvenile sanctions rather than adult sanctions.
That's correct.
And I'm having a little trouble procedurally how that goes with your complaint about what happened.
Well, I think that the court could, in essence, say that he did not understand his plea at the time and send it back to the original charges. I don't believe that ADT wanted that. What ADT wanted was to just finish out his juvenile sentence, which he would have successfully finished out if he had been advised as to what would result in a revocation of his conditional release, or if he had been provided the treatment that was ordered by the court that he in fact was not provided. At the time of ADT's sentencing,
If you
I'm
could
sorry.
stop on that. Doesn't the record say that the district court ordered evaluation and then he was to comply with any treatment recommendations? It didn't actually order treatment, did it?
The district court ordered that he receive evaluation and comply with any recommendations from treatment. An evaluation was done at the juvenile correctional facility when he arrived, shortly after his arrival, and it recommended 2 treatment programs for him. In the recommendation of the treatment programs, which were Pathways and Choices and Changes group, both of those programs, according to the treatment facility, would provide him with the tools that he would be able to use there at the facility and upon his release. That treatment was never provided to him. He was also advised, as I indicated by the judge, he was advised, basically the only thing he was told is that so straight away, if he's good and he doesn't get in trouble until he's 23, he'll never serve the adult sentence. So that's what the rules are. He wasn't told what so straight away don't get in any trouble, what that means. Now, at the correctional facility, he was a part of every one of those review hearings that they had regarding the status of his treatment, the status of his stay. At those, after the first evaluation where he was recommended to receive those 2 programs, every review after that indicated that if, upon release, he had a positive UA, that what should occur is that he should get a substance abuse evaluation and comply with the terms of that evaluation. So it's easy to believe that a child would understand that to mean that if I have a positive UA, then they're going to give me some treatment. That's not what happened. When he had a positive UA, they did refer him to treatment, but when he had a second positive UA with still not receiving any treatment, he was sent to prison for a life sentence with a hard 25 years.
Well, no, go ahead.
Didn't we have the testimony of the supervisor on conditional release that she had warned him he had one dirty UA and he was not referred to adult court? He was sanctioned in the juvenile proceeding by that supervisor.
Well, he wasn't sanctioned. What she did was she told him after the first positive UA, and I believe she testified that she told him 4 times, if you have a second positive UA, you could have to serve your adult sentence, which is a life sentence. And I believe she even told him that it could be a hard 25. But realistically, we have people charged with DUI. We have people charged in criminal cases. We have people in child needed care court, and we recognize that when somebody has a substance issue, you can't say, I'm going to take your children from you if you test positive. On a DUI person,
But you're making the argument of lack of notice, that he was never notified of the consequences of the second dirty UA, and I'm having trouble with that when he was told 4 times by his supervisor what the consequences were.
And his testimony was that he was not told that. Her testimony was that he was told that. But regardless of that, I'm making a dual argument. And my argument is, 1, he hadn't been told. And 2, He has a substance problem, and people with substance problems can have relapse problems. He has a substance problem. A substance problem.
And let me
she
get to
received
that, because
no treatment.
after the first positive UA, wasn't he then referred to some form of evaluation or treatment? And as a result of that assessment, they said he was not in need of treatment. What was the result of the initial referral after the first positive UA?
What the referral form indicated was that he was not in need of treatment. What he testified to is that
Okay, so he was referred, and then he went to some assessment, and
That's
that
correct.
assessment indicated that he was not in need of treatment.
Yes, and he testified that what he was told was that you were in the correctional facility for a substantial period of time. You were then released. You've only had one positive UA. I can't make a recommendation for you based upon one positive UA. If you have another positive UA, come back and we'll recommend some treatment. That's understandable. If you've only had one positive UA, they're not going to be able to give you a recommendation for treatment.
I'm sorry, counsel, I didn't mean to interrupt. I wanted to go back earlier in the sequence, but go ahead and finish your argument.
That was my point. So he went, was referred, was told, don't need treatment, treatment not available, and then he had a subsequent dirty UA.
He had a second positive UA.
Okay.
Had he received the treatment that he needed in the correctional facility that was recommended, that was more time appropriate, it was after he had been given ecstasy, alcohol, and marijuana by an adult and a gun and instructed to kill someone. Had he received that treatment, which was much more time appropriate, maybe he would not have had these problems later. Maybe he would have had the tools and the experience and the things that he would need to address these problems so that the first positive UA wouldn't have happened. But to just tell somebody who clearly has had a problem where 2 treatment programs were recommended, who then later apparently has a relapse, to just tell them don't use drugs or you'll go to prison is not treatment, is not giving them tools. And it is not what we are trying to help juvenile offenders with. We're trying to make juvenile offenders a better part of our community. We're trying to give them services.
Let me go back earlier in time. There was some dispute, as you pointed out, with your colloquy with Justice Johnson. Ms. Blagg testified she told him the consequences, and he said, no, she never told me that.
Yes.
Let me go back to what Judge Griffin said prior to imposing the adult sentence. The second is the adult sentence that ADT will only serve if he gets in trouble. So straight away, if he's good, doesn't get in trouble till he's age 23, he'll never serve the adult sentence. So that's what the rules are. Is there any dispute as to whether Judge Griffin actually told your client that?
No, there's no dispute as to that. I don't know what a 14-year-old knows as to don't get in trouble.
Well, and that gets to my next point. Is it your argument today that this young man, at the time he was told this, understood that it would be okay to test positive twice for cocaine use, and that would not have an impact on whether he would get an adult sentence?
It was his belief he couldn't get a new crime.
That was his belief, and
At
limited
least
to
at the time I spoke to him. That was his belief that he could not get a new crime. And as I indicated before, he had the extra issue.
Is using illegal drugs a crime?
Yes. Possessing them is a crime. And obviously to use them, you have to possess them.
But
Obviously, he was also told by the correctional facility, though, at the same time, in their reports that he reviewed every 60 days or 180 days, depending upon their review dates, that if you have a positive UA, you'll get a substance abuse evaluation and you'll do some treatment. And then he was directed to get treatment upon his release through these reports that were sent to Ms. Blagg, or to the probation department, and eventually to Ms. Blagg. That treatment never occurred until he had a positive UA, and then he just received an evaluation.
I'd like to return to the question of, even if we would agree with you that all of this constitutes manifest injustice, how does that get us to relief? Because I understood your answer to Justice Johnson's earlier question was your client did not want to withdraw a plea, which is one area where manifest injustice does allow for relief. So what other path do we have?
Well, my client's did not want to begin this case over from the beginning. He's already served the juvenile sentence in a significant period of time. His request was to be returned to juvenile court to finish out his time on his conditional release.
But what's the legal mechanism for doing that?
Well, I believe that this court can find that, I mean, the law is very clear. If you have a violation, that your juvenile sentence, your post-conditional release time is revoked and you serve your adult sentence. But I believe that this court can find that it's manifestly unjust, the violation in itself, because we didn't give him the treatment that he should have received. And that would be my argument.
I don't understand that. We could find that it was not a violation, that the use of drugs was not a violation because he didn't get treatment?
Because the state did a disservice to this youth, in that the state ordered that he receive treatment, knew that he needed treatment, and did not give him treatment that was ordered by the court. The state violated a court order in failing to give this young man treatment that was ordered by the court.
And so we would overrule Judge Griffin's ruling that there was a violation of the conditional release conditions?
Well, Judge Griffin didn't, well, I suppose Judge Griffin signed that order. Judge York had the hearing on it, but Judge Griffin didn't hear any evidence on that.
He did it in the juvenile and referred to the adult court.
Based upon an ex parte order of the state.
Which
yes.
is permitted by statute.
Yes.
And once that is done, I don't read any discretion. In fact, Judge York said, I'm not sure I'd do this if I had discretion, but statutorily I don't. That a violation means he shall go to prison. And that's a legislative matter, not a judicial matter. So the only place that we could give relief if we went back and overruled Judge Griffin's determination there had been a violation of the conditions of release from the juvenile facility. And how do we do that? How is that not the signed conditional release papers say he's not to use drugs? He admitted using drugs. So how do we find that the judge erred in making a determination that he violated that condition?
Well, I guess I would argue that it was manifestly unjust to make the decision to revoke his conditional release. And I would say that there had already been a violation of the court's order. The violation of the court's order was when the correctional facility and, in essence, the state violated the order to not provide treatment that was ordered by the judge in 2008 and 2009 and 2010 and 2011. 2012 and 2013 when he left the facility, for all those years did not give the treatment that the court ordered and that they themselves found was necessary for this young man.
You're still asking us to basically waive the statutory provisions. You're not arguing that the statute wasn't followed. The statute was followed to the letter. So what power does this court have to excuse or prevent the consequences that flow from that, other than if the statute is unconstitutional, which you're not arguing, right?
I'm not arguing the statute is unconstitutional. I guess
it sounds like you're almost making kind of a due process type argument.
That's what I was just
saying. That this juvenile defendant or offender was basically had a right to receive the treatment that was ordered by the court, and that is effectively his due process rights were violated. And that's the closest I can get to what you're describing as a constitutional violation.
He certainly couldn't get that treatment on his own while he's incarcerated for all of those years.
But the issue is not that. The issue is, does he have a liberty interest, a due process interest in drug treatment while in the juvenile facility? And what would be your authority that says a detainee in the juvenile correctional facility has a constitutional right to drug treatment?
Well, I guess I can only tell the court that it is the purpose of our juvenile correctional facility to provide treatment that's necessary for a juvenile to return them to the community in a better place than they were when they went into the facility, and provide services that we believe are appropriate for them.
I don't
and
think
those weren't
anyone's
provided.
arguing the policy. I think we agree with you 100% on in that perfect world we would all like to live in, that would happen, and that should have happened. But we have to deal with the law here, and we can't just say it's not fair. We have to get there through the law, the Constitution, the statute, or some way. And that's what we're struggling here to find the pathway that you're wanting us to follow.
I understand. I guess that if my client really did not want to begin this case over, as far as having his plea withdrawn, but if that's what it takes for my client to receive the due process and that he deserves, then that would be my request.
Is there anything in the record that would tell us why this treatment wasn't provided, as you allege?
I provided, as one of the attachments, the program planning and progress report. They don't really give a reason as to why they didn't give him his treatment. The initial assessment indicates that he needs the treatment. They indicate at one point in time that he was involved in other programs, but he was there for so many years that you would have to believe that a treatment program, they recommended two, that those treatment programs could have been provided, but there's nothing in the record that indicates why they didn't provide them to him. He was placed on a waiting list in the end right before his release.
Any more questions? Thank you, counsel.
May it please the court, Molly Hill, Assistant District Attorney, pardon me, in Wyandotte County, appears on behalf of the state, the appellee in this case. I guess just to start, I don't believe manifest injustice applies in this case. And really, the statute was complied with as far as, it was strictly complied with as far as revoking the juvenile's EJJP sentence. So I don't believe that really the court has, if they're not alleging that it wasn't strictly complied with or wasn't followed or there was a flaw in the procedure, then really I'm not sure. I agree. I don't know that the court can do anything. I don't think manifest.
Where is the fundamental fairness in an ex parte determination of a violation of the conditional release?
Well, and I think it could be seen as unfair with an ex parte order. However, the juvenile was given the additional step of having the hearing where he
But the problem is that there's at the juvenile level, when you're still in the EJJA proceeding, that the violations can be dealt with through the juvenile proceeding, as happened with the first dirty UA. But once Judge Griffin refers it to the adult court, there's no longer any discretion to do anything but impose the adult sentence. So how is that an opportunity to be heard with regard to mitigating circumstances or whatever, when the discretion is at the ex parte level and there's no discretion at the adult level? Do you understand what I'm asking you?
Well, I guess the juvenile has an opportunity to challenge whether, in fact, the conditions were violated, which he chose not to do. Instead, he chose to stipulate and agree. He could have argued, he could have not stipulated to the violations. He could have said, basically what his argument is now, I'm not agreeing, or I'm going to prove that I didn't violate the conditions of my probation, that because I wasn't given drug treatment or because the state failed me in there. But he chose not to. He chose to stipulate and agree.
Let me turn you to another concern I have. When ADT left the juvenile correctional facility on conditional release, there was a form that he signed, I assume, and laid out the conditions of his release.
time?
Correct, yes, the conditions of his, it was a form that was signed by himself. His probation officer went over it with him. I think it was part of the record. And in addition, the probation officer testified that at that time, he was told upon his release from the correctional facility that use of illegal drugs was a violation of those
Exactly,
conditions.
but what I see in that form, it talks about the consequences of a violation. And nowhere does it say the lifting of the stay of the adult. It talks about what the sanctions can be in the juvenile court, in the juvenile jurisdiction, but it does not specifically say in there. Granted, Judge Griffin, years earlier when he sentenced, mentioned that, but the conditional release conditions that say what would be violations, and then talks about the consequences, does not inform the juvenile that lifting the stay on the adult sentence is one of the consequences for a violation.
Right. And part of that is because that is a standard form that is used in all juvenile cases, not just EJJP cases. That is a standard form that's used for anyone juvenile that's under conditional release. However, Judge Griffin, as the record shows, warned the juvenile at the time of the plea, and there's also testimony as part of the record that his probation officer told him on 4 different occasions that you cannot test positive again. If you do test positive, then I have no choice but to refer it to the district attorney's office to have your probation revoked, and that the consequence of that is that the court will impose the life sentence. So the record shows that the defendant was advised although that conditional release form that he signed did not say that your life sentence is going to be imposed. However, I believe the record supports the fact that he was advised of it. First by Judge Griffin at the time of the plea at the time of the sentence itself, and when he was given the juvenile sentence, as well as the probation officer throughout the period of time. ADT makes a big deal about not giving that it was manifest injustice because it was the failure of the state to not provide drug treatment. However, I believe the progress reports indicate that at the time of his release, they decided not to do treatment because he had been in the facility for a period, I believe, of around 5 years.
And why didn't it get delivered during those 5 years? Do you have anything in the record to tell us that?
I don't know. I believe the report indicated that there was a waiting list at the very end.
Do you agree with your opposing counsel's recitation about what occurred? The judge said you will have an evaluation and you will follow any recommendations from that evaluation, and that evaluation occurred, and that the recommendations included that he get treatment at these 2 programs?
I disagree with opposing counsel in that the court ordered drug treatment. I don't believe that that's what they ordered.
I think that's a shorthand. And then when we reviewed that and she said the progression I just described, do you agree that that's correct?
I believe that that's correct, yes.
Okay, thank you.
And I believe that throughout the period of his incarceration at the juvenile correctional facility, they had reviews in deciding the progress of that treatment or what treatment was required. My understanding from the final report, was that at the time, close to his release, they decided, since he had been in the facility, had not been exposed to drugs or other triggers, that at that time they didn't believe that treatment was necessary at that time.
But that you're still not answering, I guess, the question of why wasn't treatment given during his time when he was in the facility?
When he was not in the facility?
And when he was. When he initially goes in, he gets the evaluation. The evaluation says, get treatment, here are 2 programs. And what I understand, you're not disputing any of that.
No, I'm not disputing.
And that wasn't done. Why not? And isn't that a problem?
Well, it may be a violation of his due process rights. However, I don't think that has anything to do or has the ability to overturn the imposition of the adult sentence.
Well, you may be right about that, but let's take it one step at a time. I guess are you conceding that it wasn't done and that the state failed in a duty that it had to provide it?
I would say that the record from the correctional facility indicates that he was referred to treatment, and I see from the record that that was not provided at the correctional facility.
And you, I presume, have no further information to tell this court as to why that fact happened in this case?
No, I do not. However, that being said, again, I would reiterate, I don't believe that him not being provided treatment in the correctional facility really has anything to do with the imposition of the adult sentence. He was warned numerous times.
If it was a due process violation, there's no remedy? Is it just a right without a remedy?
There may be a remedy, but however, overturning the imposition of the adult sentence, I don't believe is the proper remedy.
What would be the remedy and the path to it, in your view?
I guess at this point I'm not sure what the remedy would be. However, I don't believe. I think the...
Wouldn't we follow, I mean, I'm thinking out loud a little bit here, but typically when you have a due process violation, the question runs something along the lines of, had proper process been provided, what could we expect the reasonable result to have been? And as I understand defendant's argument, the argument of opposing counsel is, if he would have gotten this treatment, there's a strong likelihood that he would not have had the same drug problem that he had that resulted in the revocation. That's, as I understand, the best summary of ADT's argument.
Right, and I understand that that's their argument. However, I don't believe that they've provided any proof, or that's just a guess on their part. I don't think we could say with certainty if he was
Who has
provided.
the burden of proof? If there's a failure on the part of the state to provide process, and you're basically now making what amounts to a harmlessness argument, who has the burden to show that?
The state does as the burden. And I don't believe in this particular case that we could say, had he been provided that treatment in the correctional facility, could we say then that there was no way he would test positive, even despite being provided that treatment? I don't believe that we could say that. On the same token...
Counselor, there was an evaluation after the first dirty UA. And did that evaluation indicate that this person had a problem?
No, it indicated that it did not have a problem. Part of it was what the juvenile, or I'm sorry, at that time he was an adult, what ADT self-reported, and that it was a one-time thing, and that he hadn't used for several years, because he had been on conditional release for about 1.5 years before the first positive UA showed up, which would, I think, would show that it wasn't it didn't substantially affect the juvenile not having that drug treatment in the correctional facility. He was able to go, obviously within the facility, would not expect that to be an issue. However, he was out for 1.5 years at the time. So I think that, I guess, shows that the error in not providing treatment in the correctional facility was harmless. That we can't say that it was because of that he tested positive. And then he was given another opportunity for an evaluation. And again, the court's order wasn't that he has to complete drug treatment. It was that he had an evaluation and that recommendations were followed. Well, again, he was given an opportunity for another evaluation after the positive UA. And in that point, there was no treatment provided. So I don't believe the state failed to do anything in this particular time. And the defendant, the juvenile was put on notice that a violation of his conditional release, another positive UA, was going to cause the imposition of his adult sentence.
Where is ADT as we speak?
He is, I don't know exactly, he is in the Department of Corrections.
In the adult
Population.
In the adult population, yes, he is. If there are no other questions, then I would rest on my brief.
Any more questions? Thank you, counsel. We reserve 2 minutes for rebuttal.
Thank you.
The court asked about the court order. The court's order was, and it is journalized and provided to the court, was that he obtain an evaluation, drug and alcohol, and participate and follow any recommendations in treatment. That was the order that was signed at sentencing prior to sending him to the juvenile correctional facility. The recommendations of the facility regarding his substance abuse evaluation was that he received treatment through pathways, choices, and changes in challenging group. Both of those recommendations would help him with tools which he could use at the facility and upon release. So those tools would have helped him to not use drugs. People relapse. He made a significant period of time, but people relapse. Having those tools would have helped him.
And that was never complied with.
Never complied with at all. The next
But
notation,
the order was to ADT. The court ordered ADT to have an evaluation. Did he order the facility? Was the order directed at the facility?
I'd have to look at the actual transcript again, but generally what the court's order would be was, while at the facility, I am ordering him to receive a substance abuse evaluation and follow recommendations.
Normally when you sentence someone, that's part of the sentence, and that's what the person has to comply with, and they have to comply with the results of the recommended evaluation, and I don't think we normally consider that, because you said repeatedly the state violated a court order.
I would agree that on adult cases, that is what we expect. On juvenile cases, because the court understands that we are dealing with juveniles, we can't send a juvenile to the correctional facility and expect them at the age of, he was 13 when the crime was committed, but 14 when he went. We can't expect him to go to the juvenile correctional facility at the age of 14 and manage to get his own treatment. So when the court sentences somebody to the juvenile correctional facility, the court orders mental health counseling and drug treatment and things of that nature, and he's ordering that to be done while at the correctional facility. And that is standard order of the court.
Can you run the numbers for me, counsel? Arrested at age 13.
Arrested at age 13.
Assume with me that during his confinement until he was sent to the juvenile facility that he was not using any drugs. And then assume with me that while he was confined there, he was not using any drugs.
I assume that, Judge. It's not a question that I've asked, but I assume that because we all know that substances are located in prisons and in juvenile correctional facilities.
What I'm trying to figure out, adding numbers together, is the total amount of time that your client would have been clean. In other words, from age 13 until he relapsed. I think opposing counsel said 1.5 years after his release. So can you give me the numbers and how long a time period you're talking about?
Around 8 years, if in fact he wasn't using while at the correctional facility.
Right. All right, thank you. Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.